everybody. Thank you for coming. Thank you very much to Hussein Yilmaz for this very nice introduction. Thank you very much for Sumaya Hamdani for inviting me here to the Ali Bor Al-Ak Center and making me part of this really exciting schedule of speakers that you have here this semester. My presentation today has both a methodological and a substantial goal. In terms of methodology, I want to demonstrate how, in my view, the serious study of doctrine, inhering in old texts, nice old dusty texts, can enrich and be enriched by a historical account of the society that produced these texts. This approach rejects the assumption that ideas can be considered as disembodied phenomena beyond time and place. And I'm convinced and hope to show that such an approach is possible without falling into the opposite trap of reducing ideas to their social context. As for substance, in this presentation I want to tell the story of a tumultuous century in the intellectual and sociopolitical history of Egypt, in the beginning of the 9th century of the Common Era. At that point, Egypt was a semi-autonomous province of the Abbasid Empire, dominated by an exclusive class of Arab notables who followed the Maliki school of Islamic law. But by the end of the century, 3 great transformations had taken place. The supremacy of the old Egyptian aristocracy had given way to new alliances and social structures characterized by heterogeneity and social mobility. The once loyal Abbasid province had become a de facto independent state under the Turkic governor Ahmed ibn Tulun, and competition between 3 schools of legal thought had culminated in a thorough reversal of fortunes. The hitherto dominant school, Malikism, was humiliated by a briefly triumphant challenge from the Hanafi school, while the Shafi school, the underdog of the past, was elevated to unprecedented prominence. The aim of my presentation is to draw out the interconnections between these developments in the realms of law, society, and politics, and to weave these strands together into an integrated narrative. I will focus on how particular legal doctrines appealed to and were adopted by different constituencies in the 9th century, and how the fates of the legal schools were intimately tied to social and political shifts in Egyptian society. Through this narrative, I hope to show that the history of law is not peripheral to or divorced from the real history of sociopolitical processes. The real history of sociopolitical processes. Rather, legal discourses and debates went to the very heart of people's perceptions of themselves and others, and were central to their understanding of what it meant to be Arab or Muslim or Egyptian. As a consequence, legal doctrines and developments not only reflected but profoundly shaped the evolution of Egyptian society and culture. The sources on which my study is based are drawn from historical chronicles, biographical works, legal treatises, and even poetry. The material is abundant but often fragmentary, and much of it is scattered in manuscript form and in manuscript archives around the world. In light of the recent wave of revisionist skepticism in Islamic historiography and its prima facie assumption that historical sources are fabricated until proven to be otherwise, a significant part of my research has gone into verifying the authenticity of these texts. In the course of my talk, I will not stop to enumerate, discuss, or justify the sources that I've used, but I would be happy to address the issues afterwards. I will begin by introducing the central characters in this drama, namely 3 competing social groups adhering to rival legal schools. The Malikis were members of the school founded by Malik ibn Anas, who lived and taught in Medina. The Hanafis followed the teaching of the Iraqi jurist Abu Hanifa, and the Shafis were proponents of the legal doctrines developed by Muhammad ibn Idris al-Shafi'i. The fortunes of these central actors were influenced by a supporting caste consisting of the Caliph and his administration in the imperial capital of Baghdad in Iraq, as well as the governors and judges who were appointed by the Caliph to rule Egypt on his behalf, but who also pursued their own agendas and goals. Our story opens at the end of the 8th century of the Common Era. Egypt had been a loyal but relatively autonomous province of the Islamic Empire ever since its conquest by Muslim Arabs in the 640s, barely a decade after the Prophet Muhammad's death. The Arab conquerors, led by Muhammad's companion Amr ibn al-As, had established and settled in the new garrison town of Fustat, also called Old Cairo today, in accordance with Caliph Omar's prohibitions against residing among the indigenous population and against engaging in agriculture. Consequently, Egyptian society was divided between a largely rural population of Coptic Christians and an urban aristocracy of Muslim Arabs who traced their lineages back to the original conquerors of Egypt. The Arabs thus formed a distinct hereditary elite whose genealogical and financial status was enshrined in the Diwan. This was a fixed register of the noble Arab families who were entitled to an annual state pension in recognition of their military services during the conquest, as well as afterwards in staffing the militia that maintained law and order within the province. The rigidity of the ensuing social hierarchy gave the Arab elite a strong self-consciousness that was further justified by the special position that the elite saw itself as occupying in the perpetuation of the religious values of the entire community. The Arab aristocracy considered its communal practices and way of life to constitute an authentic reflection of Muslim normativity as contained in the sacred law. Divine revelation, in their view, was embodied in the tradition of the Prophet Muhammad. Those who saw and interacted with the Prophet absorbed the normative tradition and then transmitted it to their successors, who in turn carried it onwards to subsequent generations, all the way to the present. Islamic normativity, that is, Islamic law, was therefore synonymous with the faithfully transmitted, shared tradition of the Muslim community. This idea of law as communal tradition was the foundation of the Maliki legal doctrine, which granted a central normative role in the determination of right and wrong to the practice of the Muslim community, particularly as manifested in the Prophet's city in Medina. It is consequently not surprising that the Egyptian Arabs were overwhelmingly Malikis, since they shared Malik's conviction in the normative force of communal practice. This conviction was supported by the ethnic homogeneity and the closely guarded genealogical distinctions that, in the Arabs' view, guaranteed the authenticity of the tradition that they had inherited from the Prophet through his companion Amr ibn al-As. Although the Egyptian brand of Malikism downplayed the uniqueness of Medina in favor of emphasizing the equal legitimacy of other local traditions, including the Egyptian one, the Egyptians maintained a strong connection with Medina. Numerous Egyptian scholars traveled to Medina to study with Malik, and after Malik's death, Egypt became the primary center of Maliki legal thought. So far, so good? Yeah? However, Egyptian Malikism faced a growing challenge from a second school of law, the Hanafi school. Hanafism had originated in Iraq, the home of its eponymous founder Abu Hanifa, as well as his most prominent students, Abu Yusuf and Ash-Shaybani. It had begun as a local normative tradition similar to Malikism, but soon had taken a decisively theoretical turn. Abu Hanifa and his students set out to systematize the Iraqi legal tradition by weeding out inconsistencies in the body of legal rulings. Hanafi doctrine did not simply deal with real-world practices, but also addressed a growing number of hypothetical cases in order to identify overarching principles and sharpen legal concepts. As a result, Hanafism became the most theoretically sophisticated legal doctrine of the early 9th century. Its Iraqi origins and its sophistication made Hanafism the dominant doctrine of the Abbasid court in Baghdad. Indeed, the association of Hanafism with the imperial center was so strong that many sources from this period use the term Hanafi and Iraqi interchangeably. The overwhelming majority of the educated and mobile officials of the Abbasid Empire who were dispatched to serve in the provinces were adherents of the Hanafi school, and they carried this affiliation as part of an identification with the intellectual, cultural, and political cutting edge of Muslim civilization. I see the Turks are smiling when I say that. As a result, the encounters between Malikis and Hanafis in early Abbasid Egypt were generally encounters between indigenous Maliki Arabs belonging to the local elite and imperial Hanafi officials who were outsiders both to Egypt's social order and its normative tradition. These foreign appointees, particularly when serving as judges, did occasionally attempt to influence legal practice in Egypt in the direction of Hanafi doctrines. However, in the early decades of Abbasid rule in Egypt, the delicate balance of power between the Hanafi favoring imperial center and the staunchly Maliki provincial elite and militia meant that Hanafism did not initially succeed in gaining a permanent foothold in Egyptian society. One big issue of dissent between Hanafis and Malikis was the issue of endowments, of endowed property. Whether somebody can endow a property for public interest, for example, and whether this remains then in the public hand, or whether if this person dies, it gets inherited by his children. Right? And this became a major problem of these Hanafi judges coming from Iraq to Egypt, and they granted these endowments to the heirs, right? And there was, you can imagine if suddenly I don't know who endowed, well, we know who endowed this center. If suddenly the inheritors of the endower would suddenly say, yeah, okay, that was fine while he was alive, but now afterwards we want the money back, right? That would produce all kind of problems, and these kind of problems, real, societal issues, were at stake here when these Iraqis came to Egypt. Entering the scene at the very beginning of the 9th century is our third major actor, Muhammad ibn Idris al-Shafi'i. In contrast to Malik and Abu Hanifa, who were very much part of particular local traditions, al-Shafi'i was a true cosmopolitan who had spent his life in half a dozen different countries without putting down roots in any of them. At the age of 50, having lived in Palestine, Mecca, Medina, Yemen, and Baghdad, he settled in Egypt, where he died a mere 4 years later. In that brief span of time, he completed his development of a radically new theory of Islamic law. At his arrival, al-Shafi'i was initially welcomed with enthusiasm by the Maliki elite. He boasted an illustrious lineage, as he was a direct descendant of the Prophet Muhammad's great-uncle, Abd al-Muttalib. His scholarly pedigree was likewise impressive. He had studied extensively with Malik in Medina and was considered an important student of Malik's, but he had also engaged and debated with Hanafi scholars in Iraq. Al-Shafi'i's experience in defending Maliki doctrine against Hanafi challenges must have seemed promising to the Egyptian Malikis, who could not have been unaware of the weakness of their legal approach when confronted by the methodological sophistication of the Hanafis. The Maliki doctrine, rooted as it was in a lived communal practice, simply had no answers to offer to the myriad hypothetical legal questions generated by the Hanafis. Accordingly, we have several reports of prominent Malikis eagerly joining al-Shafi'i's teaching circle in order to absorb the latter's techniques of legal reasoning. It rapidly became clear, however, that the novelty of al-Shafi'i's approach went beyond mere technique, and in fact constituted an entirely distinct legal theory that was based on a fundamental critique of Malik's teaching. Whereas Malik had located normativity ultimately in the Muslim community, al-Shafi'i enshrined normativity exclusively in texts. For al-Shafi'i, the relationship between the believer and divine revelation was not one of an individual to the community of which he or she is part, but rather a relationship between an interpreter and a closed canon of sources consisting of the Quran and Hadith, or reports regarding the actions and statements of the Prophet. In this scheme, communal practice carried no normative weight of its own. What al-Shafi'i was thus proposing was the delocalization of Islamic law, a shift that could be experienced either as the uprooting of communally grown values, or alternatively as the liberation of religious values from the straitjacket of local tradition. Given its radical novelty, al-Shafi'i's innovative theory of the law did not attract much of a following among the Egyptian Maliki elite, nor among the Iraqi Hanafis residing in Egypt. Instead, the majority of al-Shafi'i's early followers in Egypt were so-called clients or mawali, members of non-Arab families who had converted to Islam and been incorporated into the social and cultural network of an Arab tribe through manumission from slavery or a contractual agreement. Though such clients possessed an adopted Arab genealogy by virtue of their association with an established tribe, their status within the social hierarchy remained largely subordinate. As a consequence, the client's self-image was not as closely wedded to the Maliki notion of a continuous normative communal tradition, and they were more open to the merits of al-Shafi'i's textualist approach, which, in effect, leveled the playing field between Arabs and non-Arabs. In al-Shafi'i's system, access to revelation did not require membership in a particular tradition, but could be secured simply by consulting the authoritative texts. And the correct understanding of these texts was based, first and foremost, on a sound understanding of the Arab language, a skill that, unlike a genuinely Arab genealogy, could be acquired. at least if you have a good Arabic teacher. The dramatic social and political shifts that led to the reversal of these three groups' fortunes began with a decline in the power and influence of the Egyptian Arab elite. Beginning in the mid-8th century, the dominant status of the Arabs in Egyptian society was gradually eroded by several developments, particularly the increasing prominence of non-Arabs in positions of merit-based leadership, the dilution of the tribal loyalties of the early conqueror society by the emergence of competing economic interests, and the cumulative centralization pursued by the Abbasid imperial administration. The first of these trends, the growing heterogeneity and social mobility in Egyptian society, was the result of conversion to Islam. These created a class of Muslims who, though excluded from the genealogically constructed primacy of the Arabs in the Diwan, nonetheless participated actively in religious discourse and in many cases achieved prominence as scholars and public officials. This growing diversity was reflected in a widening spectrum of interpretation and disagreement regarding religious norms. The influx of upwardly mobile newcomers, whose origins lay outside the tight tribal matrix of Arab culture, thus undermined the fundamental premise of the Arab elite's claim that its communal values embodied Islamic normativity. Such a claim rested on the presumption of complete unanimity, as well as unbroken continuity in the transmission of the authentic prophetic tradition, but this position was becoming increasingly questionable. The second trend, the development of competing loyalties, was the result of Arabs contravening the original orders of Caliph Omar by settling in the Egyptian countryside and taking up agriculture. This process had begun in the mid-8th century, when the imperial government had permitted Arabs from Syria to move to the Nile Delta as a means of suppressing occasional tax revolt by indigenous Egyptian peasants. After a generation had passed, however, unsurprisingly, the economic interests of the settled Arabs had become fused with the interests of those whom they were meant to police. The shift led to new tax revolts that this time saw Coptic Christians and Muslim Arabs of various tribes allied against the elite Arab militia. Thus, the neat order of Arab Muslims loyal to the empire, extracting taxes from non-Muslim and non-Arab peasants, began to break down. The third trend of imperial centralization had far-reaching implications for the hitherto broad autonomy of the Egyptian elite. Important economic and social functions, such as the supervision of religious endowments and the property of orphans, were progressively moved from the private sphere to the realm of bureaucratic control, and the participation of the community in the judicial process was drastically curtailed by new rules that limited the people whose witness statements would be accepted in court cases to a selected few. In the military realm, the supremacy of the Arab militia as defenders of the province was dealt a decisive blow in 799, when the Abbasids stationed a permanent foreign contingent of troops in Egypt. This move was a response to the unwillingness and inability of the local militia to quell the Arab Coptic tax revolts in northern Egypt, and its effect was to remove the justification for the continued payment of the state pension. The Diwan system was subsequently discontinued, depriving the elite of both an important source of income and a major marker of social distinction. So for about 200 years, there was a continuous elite of Arab conquerors and their descendants who were paid this regular state pension and that distinguished them as this elite, and it was discontinued after about 200 years. The early years in the 9th century thus witnessed the erosion of the prestige, economic basis, and internal loyalties of the old Arab aristocracy. Its downfall was sealed by the Abbasid civil war of 809 to 813, which created a power vacuum in Egypt. The ensuing civil strife, which saw Egypt divided between two warring factions, resulted in substantial loss of life among the elite, particularly through the deaths of young men who represented the potential leaders of the community. With the weakening of the socio-political clout of the aristocracy, who formed the central constituency of Malikism in Egypt, the Maliki school itself was exposed to attack by its rival, Hanafism. The principal threat came from centrally appointed, proselytizing Hanafi judges. These judges could rely on the support of the imperial administration for their efforts to change legal practice in Egypt, and given the shifts taking place in Egyptian society, they were less and less inhibited by the pragmatic need to take into account the influence wielded by the Maliki elite. Piecemeal reform were undertaken by Hanafi judges from the 780s onwards, but it was the ambitious and ruthless program of persecution that was carried out in the 1840s under the direction of the Hanafi judge Ibn Abi Layth al-Assam that finally and seemingly irrecoverably ended the reign of Malikism in Egypt. Al-Assam served as the Grand Judge of Egypt between 841 and 851. He was charged by the Caliph with the implementation in Egypt of the so-called quranic inquisition, the Mihnat al-Quran, the infamous and eventually unsuccessful attempt by the Abbasid regime to settle by fiat the perennial debate over the createdness or otherwise of the Quran. Al-Assam, so this was in essence a theological issue, right? Theological, not a legal issue. Al-Assam set upon this task with zeal, demanding that all jurists, hadith scholars, court personnel, and even callers to prayer affirm in public their commitment to the doctrine that the Quran was created, a position that was accepted by many Hanafis, but was vehemently denied by most Malikis as well as Shafis. Anyone who failed to comply with the order was subject to harsh punishment. Although the Inquisition ostensibly centered on a theological claim, sources from the 9th century show that the real targets of Al-Assam's campaign were the legal schools, and that he used his power at the helm of the inquisitorial machinery to promote Hanafism at the expense of its rivals. This agenda can be seen, for example, in a long poem composed in the 840s by the Egyptian poet Al-Jamal in the praise of Al-Assam. In the section of the poem that speaks about the Inquisition, 10 out of the 13 lines deal with the rival legal schools rather than theology. These extol Al-Assam's success in defending the teaching of Abu Hanifa and in crushing the popularity of the Shafi'is and Malikis. About the latter, Al-Jamal says, in very rough prose translation, "They had enjoyed widespread renown, but you extinguished their fame so that they are no longer remembered." Al-Assam singled out Maliki scholars for public humiliation and banned both Malikis and Shafi'is from teaching in the central mosque, which at this time represented the primary venue for promulgating and popularizing legal teaching. The final nail in the coffin of Maliki supremacy came in 851 when Al-Assam accused a prominent Maliki family, the Banu Abd al-Hakam, of misappropriating government property. The family's entire assets were seized, many of its members were imprisoned, and one of its leaders died under torture that was used to extract information about the family fortune. Even though the ruthlessness of Hanafization under Al-Assam waned after his removal from office in 851, the new breed of Abbasid officials in Egypt that followed Al-Assam continued to promote Hanafism with an intensity that was unprecedented before the Inquisition. These officials were military men of primarily Turkic and Armenian origin, often recent converts to Islam. The rapid rise of power of this class in Egypt as well as elsewhere within the Islamic Empire reflected the changing ethnic and cultural composition of the Abbasid state apparatus. In 836, Caliph al-Mu'tasim had moved the imperial capital from Baghdad to Samarra, about 80 miles to the north, where he relied increasingly on his Praetorian Guard of foreign-born slave soldiers to fill military and administrative posts. Under al-Mu'tasim's successors, these officials became the de facto power holders in the Abbasid Empire, ruling both the capital as commanders and the provinces as governors. The new Turkic and Armenian governors generally had little experience or interest in the scholarly discourse of law. Nonetheless, they had absorbed basic Hanafi teaching as part of their training in Iraq, and once in Egypt, they had no scruples in applying this teaching with utter disregard for the local Maliki practice. For example, a police chief by the name of Azjur the Turk, who was appointed in 867, demanded that all worshippers in the central mosque of Old Cairo must pray according to the Hanafi rite. In one stroke, he thus outlawed the way that Egyptians had been accustomed to praying ever since the Muslim conquest. Simultaneously, the new administration made little pretense of participating in the cultural practice of the community. Beginning with the first Turkic governor, the rulers of Egypt no longer led the congregation of Fustat in communal prayers on Friday, as all the Arab governors had done before them. Al-Assam and his successors' Hanafization policies were directed primarily against the Malikis as the dominant elite, but the Shafis also felt the force of suppression. As I mentioned, Shafis alongside Malikis had been banned during the Inquisition from conducting their lessons in the central mosque. The leader of the Shafis at the beginning of the Inquisition, Abu Yaqub al-Buwaiti, had stubbornly refused to obey the command to profess the createdness doctrine and had been sent in chains to Baghdad, where he died in prison. However, his successor as the leader of the Egyptian Shafis, al-Muzani, appears to have reached an accommodation with the Hanafi power holders. Al-Muzani had been a Hanafi himself before becoming a student of a Shafi, and sources suggest that he enjoyed the trust of al-Asam as well as other Hanafi officials. This association with the people in charge of the Inquisition, along with the suspicion that he in fact generally believed in the createdness of the Quran, deeply tarnished al-Muzani's reputation for at least a decade and a half afterwards. Historians report that his teaching circle in Fustat dwindled to no more than a handful of students. During the 1850s and 60s, there is very little evidence of Shafi scholarship and teaching at all, suggesting that al-Muzani's disgrace may have affected other Shafis too, by extension. In lists that contemporary traveling scholars compiled of the teachers under whom they had studied in Egypt, al-Muzani's name is conspicuously absent, though some of his fellow Shafi students are occasionally mentioned. For a while it might have appeared that Hanafism was set to dominate Egyptian legal discourse. It was backed by the newly strengthened military elite from Iraq and unencumbered by indigenous opposition, which had seen its foundation decimated through the turbulent decades between 800 and 850. But the growing weakness of the Abbasid central state triggered a fundamental change in patterns of patronage and political support for legal scholarship in Egypt. This change was initially initiated by the appointment of another Turkic military leader, Ahmed ibn Tulun, as the governor of Egypt in 868. Ibn Tulun embarked on the pursuit of financial, political, and military independence from the Abbasid state. He ceased forwarding taxes collected in Egypt to Baghdad, and even came into military conflict with Abbasid forces in the course of an expansionist move into Syria. Given the close alliance of the Hanafi establishment with the imperial administration, it is not surprising that a gap began to emerge between Ibn Tulun and the Hanafis. In 883, Ibn Tulun endorsed the weak Caliph al-Mu'tamid against his challenger al-Muwaffaq, and ordered the Hanafi judge of Egypt, Bakr ibn Qutayba, to curse al-Muwaffaq in public. Bakr refused, and Ibn Tulun had him arrested. Subsequently, the Tulunids appear to have adopted a policy of gradual divestment from Hanafism, though Ibn Tulun's son, Khumarawayh, appointed another Hanafi to be Bakr's first successor as Grand Judge. The appeals court judges were subsequently all Shafi'is, and after a few years the post of Grand Judge was also given to a Shafi'i jurist, Muhammad ibn Uthman Abu Zur'a, who thus became the first Shafi'i to assume the position of Grand Judge of Egypt. Already Ahmed ibn Tulun had encouraged members of his household to study Shafi'i law, and we know that two of his sons as well as other prominent court personnel became trained Shafi'i jurists. Ibn Tulun's son Adnan is reported to have said the following about a Shafi'i student, Rabi'a, who played an important role in popularizing the Shafi'i's ideas in the Tulunid court. I quote, "God showed his generosity by extending the life of Rabi'a until the world had studied with him. We studied under him when we were still adolescents. Hitherto the Malikis had been dominant in Egypt, but then God cast love for a Shafi'i and his disciples into my father's heart. Disagreements and clashes broke out between the Shafi'is and the Malikis in Egypt, and my father always sided with the Shafi'is. He was generous towards Rabi'a and supported him financially and ordered him to continue to visit us, and he prodded us to listen to a Shafi'i's works. So we studied a Shafi'i's works with Rabi'a." End of quote. Beyond Adnan's comment about God casting love for a Shafi'i into Ahmed ibn Tulun's heart, the reasons why Ibn Tulun and his successors shifted their support from the Hanafi to the Shafi'i school are nowhere explicitly discussed. However, it seems likely that the identity of Hanafism as the imperial doctrine of the Abbasids made it unsuitable for the independence project of the Tulunids. On the other hand, Malikism, with its close links to the old Egyptian elite, must also have appeared unattractive. Against its two rivals, Shafi'ism offered several advantages. It was allied with neither the imperial center nor the old Egyptian social order. And its textualism, which divorced law from particular local settings and located the fount of normativity in a disembodied corpus of canonical texts, fitted the needs of the essentially rootless Turkic newcomers. These sought not only political independence, but also an independent basis of Islamic legitimacy, which was ideally provided by Shafi doctrine. The golden age of state-backed Shafiism did not last very long. In 905, the Tulunid dynasty was overthrown by an Abbasid army from Baghdad, and many of the dynasty's Shafi appointees lost their positions in the judiciary. But the brief period of prominence led to a blossoming of Shafi thought and scholarship that had enduring consequences. Scores of jurists from both Egypt and elsewhere studied with the Shafi students, copied their works, transmitted them to others. By the time Shafis lost the official support provided by the Tulunids, it was firmly entrenched as the dominant school among Egyptian intelligentsia, and traveling scholars had spread Shafi doctrine from Egypt to all corners of the Muslim world. Indeed, ever since that time, Shafiism has been the prevailing legal school in Egypt. To conclude, what I've sought to demonstrate through this very brief narrative of a slice of Egyptian history is that the histories of law, society, and politics in 9th century Egypt are fundamentally intertwined. Indeed, I would argue that none can be adequately understood without the others. First, I hope to have shown that the legal doctrines of Malikism, Hanafism, and Shafi'ism were adopted by divergent social groups for very specific reasons, and that these reasons were frequently tied to a group's self-definition and identity. The Maliki and Hanafi school acted as carriers of local identities. The Maliki identity, with its emphasis on continuity and tradition, was based on descent from the Arab conquerors of Egypt, while the theoretically sophisticated and expansionary Hanafism was linked to Iraq as the intellectual and political center of the Islamic world. The scripturalism of Shafi'ism, on the other hand, transcended localism and thus attracted primarily non-Arab and cosmopolitan Muslims. Second, I have argued that the support or otherwise of political actors for particular legal schools was often guided by the pursuit of strategic goals. It seems plausible, for example, that the Tulunid support for the Shafi school reflected an awareness of the fit between Shafi doctrines and the dynasty's drive for greater independence from the Abbasid Empire. And third, I hope I have pointed towards the extent to which the historical trajectories of the legal schools were tied to the social and political fortunes of their adherents. A dramatic example of this connection is the terminal decline of Malikism in Egypt as the result of the downfall of the old Arab elite. However, the doctrinal challenge caused by social dislocation and the disruption of traditional practices also played a significant role in undermining the foundations of Maliki doctrine. In a context of profound societal change, an organic communal tradition must have seemed an increasingly shaky basis for religious law compared with the apparent immutability of the sacred scriptures. The complex reasons for the shifts that took place in 9th century Egypt thus serve both to illustrate the importance of analyzing social and cultural processes together and to warn of the potential pitfalls of reductionist explanations that posit a simple and unidirectional causality between the two. In the wider scheme of things, this case study of 9th century Egypt documents an important phenomenon in the history of Islamic societies, namely the dissolution of the conquest identity that had fused Islam, Arabness, and loyalty to the Islamic Empire into a unitary whole. In the Egyptian context, which was characterized by the replacement of the Arab ruling elite by non-Arabs and the presence of a sedentary non-Muslim majority population, this process of dissolution took two seemingly contradictory directions. On the one hand, it led to a localization of political and economic interests and loyalties, as we saw, for example, in the case of Arabs turned farmers who found themselves rebelling against the central government in alliance with Coptic Egyptians. On the other hand, it promoted a universalization and de-ethnicization, I'm not sure whether that's actually a word in English, de-ethnicization, of Islam. Given the growing number of new converts to Islam and their increasing prominence in the fields of politics and scholarship, there was rising pressure towards the discovery and legitimization of a new, non-ethnically defined basis for religious values. Scripture, rather than tradition, was the answer that took root in Egypt and sprouted into the Shafi school of law. Thank you.